My name is Deanna Estefan. I'm one of the attorneys here at Jackson Bergman. I focus predominantly on family court and matrimonial cases. Today I'm going to talk about when a third party, somebody who is not one of the biological parents of a child, is seeking custody of that child. Often we see it with grandparents, other family members, or close family friends of the biological parents. In New York State, biological parents have more rights to a child than any other person, which makes sense. But there are certain situations in which a third party may be able to successfully petition for custody of a child. We call these extraordinary circumstances cases based on the language set out in the Court of Appeals case Bennett v. Jeffries, which laid out the foundation for proving these types of cases. What constitutes extraordinary circumstances is not necessarily black and white, but the courts over the years have given us some guidance. Things that do constitute extraordinary circumstances, considering surrender, meaning a written termination or intent to terminate your parental rights. Abandonment, a parent that is permanently out of a child's life. Typically, it needs to be for more than 2 years. This is not a case of a parent who is having infrequent visitation or inconsistent visitation, though. Persistent neglect, in cases in which a child's emotional, physical, or mental well-being is harmed, and it's happening over and over again. There's parental unfitness, and then there's the final catch-all, other similar extraordinary circumstances. This could include significant domestic violence in the home. It could include persistent drug use, criminal issues such as a parent who's going to be in prison or is in and out of the legal system, in and out of jail. Physical abuse of a child obviously would lead to having extraordinary circumstances. Unfortunately, in most of these cases, Child Protective Services and the Department of Social Services tends to be involved. Courts can also look at the quality of the child's relationship with their biological parents compared to with the non-parent. The length of time in which a child has been with the non-parent can be a factor, although it usually needs to be coupled with other factors as well. Typically, things that are not found to be extraordinary circumstances, like previously mentioned, limited visitation or inconsistent visitation. The fact that the non-parent may do a better job raising the child than the parent, or a child just having them live with a relative. Those would not rise to the level of extraordinary circumstances. When you are dealing with one of these cases, there's 2 prongs to the case. The first is that the non-parent must prove the extraordinary circumstances. If you are successful at doing that, you have what's called standing to continue on. At that point in time, then what you would need to prove to a judge is that it is in the best interest of a child for the non-parent to have custody over the parents in this case. In all family court cases, the foundation that a judge is always going to be looking at is the best interest of the child. This is a general overview of non-parent custody cases. If this is a matter that you think you are having in your life, you can always call Jackson Bergman, and we are more than happy to assist you in this. Thank you.